Okay, agenda approval. The agenda is public comment, and I'm going to suggest that we reverse the order of the next three things that are listed. We do the racket sports first, the CPI violation second, and the review of GM objectives third. And we adjourn to a closed session for personnel issue GM evaluation. Is the adjustment to the agenda okay with everybody?
I have a copy.
Get your one.
I'll get you.
Oh, is there one here?
I got it working.
Tom, run that again. What are you doing again?
Here. Stick with it. Stick with it. All right. Just do one. Stick with it. Do 1, 2, 3, 4.
Anybody else need one?
Thank you. Well, that makes sense.
Any objections to that change?
No objection.
Hearing none, move on. Move right to what I have to do tonight. We'll move right to public comment.
Sorry, I couldn't hear what you said, sir.
So we will move to public comment.
I'd like to make a comment. Go ahead. Sorry.
Name and address.
Burley Howell.
Oh, here we go with Mike.
Burley.
Hang on. Hang on, Laura. Hang on.
Yeah.
Thank
He
you.
knows it. Right again? No. All right. My name is Cora Lee Howell. I live at 17 Fossey Grange in Pine. I've lived here for eons. And I'm part of cattle community. And I'm very strongly want the board to consider 2 ports that have been actually allocated to us previously be highly considered based really on the amount of time that cattle play on those courts. They're there from 7 o'clock in the morning till 10, 11 o'clock at night, 7 days a week, 365 days a year. We play all the time. So I ask that you please give us desperate need.
Thank you.
May I just ask, Ms. Powell, was your first name Laura Lee or Cora Lee?
Cora.
Cora, thank you.
Hi, I'm Jim Freeman. I live at 60 Boston Drive. I've been very active in the platform tennis community since I moved into Ocean Pine, 2004, and I got very involved in it, became president of the association. While I was president, it became one of my priorities of our group to try to get more courts because our population membership had grown and grown and grown. And so we're at the point now where we could really use the 2 courts. We're very crowded, and we worked very hard to get them. I've talked to Terry, talked to Thompson. I even made a speech and a presentation in front of the Park and Recreation Advisory Committee, and thought I had their approval. So we really appreciate all the time everybody has spent listening to us and talking to us, and we just hope that you see fit to start. Thank you very much.
Thank you.
Hi, I'm Diane Harris. I live at 113 Hingham Lane. I think our paddle tennis group is really what Ocean Pines is all about. We're a very warm, welcoming, friendly group of people. We have many social events, tournaments just for fun, hot dogs, get-togethers. We have just half of our membership there. We've got 60 people trying to play on 4 courts. We definitely could use the extra 2 courts. And I just think this is what we're about. Thanks.
Thank you.
My name is Don Pelicana, 548 Ocean Parkway. I'm a member of the Parks and Recreation Committee, and November of 2012, Jim Freeman and his fellow paddleball officers made a presentation to Parks and Recreation Committee, and we thought it was a good idea to support and to grow the paddle community. I think the one point I want to make is that our season begins probably in the fall, and we go through the whole winter and into spring, and we do hang on through the summer. So I think it would be helpful if our courts, and I don't know if there's anything holding it up, if our courts were done first, so that we could have use of them beginning now through next year, and then continuing after that. Thank you very much.
Good evening. I'm Linda Horst, and I reside at 374 Ocean Parkway here in the Pines. And I absolutely love racket sports in general. I was an avid tennis player when I was younger. I have played paddle tennis since I was part-timer here in the Pines, before I became a full-time resident. And I taught pickleball to young people for 17 years. I love them all. I have friends in all of them. But we only have 0.4% of our membership that does not reside here at this time of time, while 30+% of the pickleball players do not reside here in the Pines. Okay, this is based on our membership rolls. We really need platform tennis paddle courts as soon as we possibly can get them, because we are so overloaded. We cannot slide into the gym here when the weather is too cold, too windy, too hot. We do not have that luxury of playing in there on all time. I enjoy pickleball. I like the people that participate in it. And yes, I've played indoors because the outdoor weather hasn't been conducive. But I play paddle in 0-degree weather. I played in 10-degree weather. I played in 100-degree weather. I play at all times. And we really need courts to accommodate the people that we have nowhere else to go. They are our courts. It is an outdoor facility at all times, and it is 365. And we really do need those outlets. And I really would appreciate your consideration for that. Thank you very much.
June Freeman, 60 Boston Drive. Let me begin by saying I know you guys have called a special meeting for us, and we appreciate it. And we realize that you're getting overtime, getting paid overtime. But what we want to say is we so appreciate you listening to us and hearing us. And I know that if you had promised that we would get our courts in this fiscal year, and I know you want to do what's right. You always have. So we're just asking you to really go back and look and see what was afforded, promised to us, and would you please help us get what you wanted to give us and what you're to. And thank you for your time.
Anybody else?
Joe Reynolds, 84 Watertown Road. I want me to use the mic. The mic that doesn't work. Gotcha.
Everybody else, you stand. Why not you?
Do I stand in back of it or in front of it?
You're good.
I don't want to block my beautiful body.
Tell you what, Joe, face the other direction.
I sent an email to the board of directors after I saw the agenda and asked a couple of questions. I asked what the motion was for the CPI violation. What's the text of the motion? And with regard to the racket sports complex construction, an item on the agenda, discussion and action. And I asked what action would be taken. Someone give me the text of some motion to be made, or we need to pass the motion before association members can know what's in the motion. I received received no response. I realize these folks are here today because they have been anticipating, desire to see things in the budget that they hope to be done, and I understand that. I'm a past president of the Ocean Pines Tennis Club. But, following Ms. Holt's theory, I do not want to play. And not much that I say has an impact anyway, it seems. But I would like to instead share with you how past OPA President Bill Zawacki sees this board of directors as operating far too often. This is a direct quote. Today, the modus operandi has 6 steps. 1, no plan, no motion in advance. 2, without member input, discuss the topic. 3, verbally make up a motion on the fly. 4, vote, and results generally not recorded by individuals. 5, allow staff at a later date write the motion into the minutes. Finally, number 6, allow the GM to disregard the whole thing. Those aren't my words. As a past president of this association. Thank you very much.
Anybody else? Okay. The first thing we're going to discuss is the action on the Racket Sports Complex Court construction. And coming out of our last meeting, one of the directives or strong suggestions from the chair here was that the paddleball folks, platform, sorry, I'm calling it the wrong platform, meet with Bob Thompson, and what happened was ultimately Sunday afternoon at 4 o'clock, not only did all 3 sports come together, 8 of the 9 folks that had been appointed to take seats on what is still technically known as the Tennis Advisory Committee, but is in the midst of evolving to be the Racket Committee, met on Sunday afternoon. I was there. Jack Collins was there from the board. Listened to each other. 3 sports talked to each other. Ultimately forwarded to the board, which I forwarded to every member of the board, a letter of request which spells out very specifically what it is all 3 sports have aligned together to do and what they would like us to have happen. So they are unified. Their message is clear as to what they want. We have received it. So we are listening to the members, attending meetings and listening quite often to what people want. In my opinion, we are at a point where we now have a unified message from the Racket Sports as to what they would like to have. And what I'm going to ask for Bob Thompson to do is just quickly go over the various pieces of the Manklin Creek complex that were basically up on the screen at the last meeting, just to go over again with various pieces that are there so that we understand the various parts of what the overall conceptual plan is. And then after that, we'll have a discussion of actions, next steps, and that kind of thing. So at this point, Bob, I'll turn it over to you to go over kind of a schematic of what was on a screen at the last meeting, just to go over it for us.
I'll hold it.
You want to play Vanna?
Yeah, the folks aren't going to see it, but I'm presenting to you guys stuff.
I can't see.
Oh, you can't. All right, I'll move to this side. It's irrelevant then. I'll leave it there for a second. I'm going to just point out to the board, one of the things that was asked of us is to go back and look at the plan with the paddleball courts and put it on an actual plan. What we did following the meeting on Sunday, Tim Vaughn actually drew up the initial plan. He drew, this was something that was talked about more of a master plan so you can see what the future is going to look like. If you recall, the original platform tennis courts were staggered right in this area. So when we walked the site, we wanted to line them up with the two that are already there, move the hut to here. And then these were identified as two future court opportunities. Okay, so you'd have a row here. That stayed the same from last that you've seen it. This is the only change because I was asked to provide kind of a longer range plan of what it would look like. These are the platforms that the platform group is speaking of and that were potentially in the budget for this year. That's future, yes.
And where's the hut right now?
The hut's right here right now. And the proposal is to move it here. This wider area is just a little bit of a patio area. Tim and I were talking about that over the weekend. Notice the blue is the actual screening that would be the landscape. So what we would do is create a little patio area because they have a grill and some other things there that are just up against the building.
Presentation has a future a larger hut house area. Is this big enough to accommodate?
Well, that's the current building and that's the pad, so it's 3 times the size.
The pad, not building.
Right.
You're moving the existing building.
The building is basically
moving
being
the
relocated.
existing building to here, but we're going to put it on this pad.
So they have more.
So they have room there out.
I think, Marty, were you asking the question that?
Marty, the existing building that is there, the hut,
Yes.
is simply going to be relocated. It's not going to be grown or shrunk at this point. It's simply relocated and the reason is fund.
There was talk.
I understand.
But there is space there. Because you have this pad.
Yeah.
You have the space.
Potentially there's space there if you want to expand the building, yes.
But at one time there was talk about this building.
That's not what we're talking about.
No, but at one time there was discussion. So there's space. You still have space.
Okay. Now, how for these?
I felt when we walked, I didn't, and I said it up front, didn't like the stagger to put it too close to the ball field. I think the alignment here, moving of this, it still gives us plenty of space here for the ball field situation. So I'm very comfortable with where they are there. I don't think it creates any issue for us.
I like the north-south alignment so that it's not an issue.
And you got the
What we showed before with the 84 or playground.
No, I was there. He explained it. He explained it. I'm very familiar with it.
I thought you were.
Yeah.
That's all I have.
Just so the folks in the audience know what the heck they were just looking at, if you weren't there on Sunday, what is on this schematic now is the 8 pickleball courts in the same spot that they were going to be using last week. It now shows 2 additional paddleball courts being positioned a little further away from the softball field than they were originally thought of. The actual hut that is currently for the platform folks is simply relocated. If you're looking at the paddleball courts, it's relocated to the left onto a cement pad so we get rid of the rocks that are over there. And on that drawing is 2 additional platform area for 2 additional platform courts at a later date if needed, which aligns, I believe, exactly with what was in the letter that we got from the 3 sports. And John, is that, you're shaking your head, yes. So that aligns perfectly with that. So we have a schematic that aligns with what has been requested. The thing that we do not have yet, and the thing that I would like us as a board to simply say is, Bob, we would like you to keep moving on what you just presented here. Get us the actual plan, get us the actual prices. Let's figure out what the actual expenses are going to be, which I'm assuming you would have been doing anyway, but I want the board to basically state that what you just saw here, we're not approving any dollars tonight, we are approving moving forward getting the plan, getting pricing, what you just saw.
So I understand.
Yes.
We're approving what we've been talking about since last September. Master plan.
It's basically going to get the price of what you just seen.
Well, the master plan, which is showing, that we didn't address how many this was showing.
Eight.
It's eight.
Yes. Sir. Where did 8 come from?
I think one of the topics of discussion was, I always get this bass act, economies of scale, Marty, you know, which you're probably more familiar with than I am. You know, I'm familiar with it from a banking standpoint. But a builder, he gets his people on the spot, he gets a concrete raw there, and he can lay, 10, 15 townhouse pads rather than 5. So he'll do that because it's more economic to do it that way. So if you do the 4 pickleball courts, it's not just laying blacktop or concrete or anything of that nature. You got to do site prep. And in doing the site prep, it's a lot of stuff goes into it other than just borrow material. So consequently, instead of doing 4, coming back and doing it over again, the thought process is to do the whole thing and make it contiguous so that it's, in the long run, it's probably less expensive to do it that way per court.
Well, let me ask this. By going from 4 to 8, what is the impact to the playground? Can we do the 4 without impacting the playground?
Are you talking pickle or paddle?
I'm talking the pickle. Paddle's nowhere near the playground.
Correct. But there's 8 of the schedule.
That's a good question, Marty. I didn't know the answer.
Because your economy of scale goes right out the window.
Yeah.
You got to spend 50 on the playground.
Bob, you got a handle on that?
Yeah, the plan was to move the playground as part of the project. So it would depend on the alignment of the 4 courts versus 8 courts. Are they lined up back to back or lengthwise? But it does put it, I believe it's going to, and I'd have to walk back over and try to scale it real quick, but I believe it's going to put it too close to safely operate. But it will end up impeding on the playground site, the current playground site.
Well, but there are so many deficiencies in that playground already that it needs to be corrected.
I hear that, and I've done a lot of investigation on it, and it can all be corrected way less than $10,000. A lot of it is covered by the manufacturer. All the head traffic is like that gets over, gone, and free. Okay, we'd always talk about 4. I'm still wondering where the 8 come from. The economy of scale hasn't put me over the edge. And the track record of membership, you know, we heard people say tonight, this is not meant to pick on anybody, but I've never heard them say, growing, 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 growing. Our platform tennis membership has fallen over 35% since 2010. We had 111 members in 2010. We had 70. I'm not going to argue that we don't need more paddle tennis courts because I've seen people waiting. Pickleball, on the other hand, I can't go back to last year's pickleball membership because there wasn't any.
Well,
but I do know that we only had 63 pickleball memberships sold. As of today, do the math, that's about 6 people per court if we build 8. That's a better ratio of courts than you get at CCOG. So, I'm just wondering how we got to 8 instead of 4. So far, I haven't heard even the slightest reasonable argument.
You mean what I said wasn't the slightest reasonable argument?
Exactly.
Oh.
All right. The point is there across the board agreement, move forward, get the pricing on this so we know what the costs are? Because we're not voting on any dollars tonight anyway, but let's go get the prices.
I would imagine that if it comes back just with 8 pickleball tennis courts and it's way out of line, we get back down. Easier than we go forward. I just don't want this to be an okay to start moving playground.
Fair enough.
until we have all the numbers. I don't want to see that playground move.
Yeah, I have a question, and raise it. We have a very, very busy agenda tonight. Let me just remind something. Jot it down somewhere. We put a lot of pressure on Bob Thompson. We have put pressure on him to manage a drainage committee. He's got a meeting coming up with some people from the county, including a county commissioner, on some specific issues as they relate to drainage. He is going to be coordinating with the county a water line replacement along Ocean Parkway sometime during this fall going into the winter. He's involved in an IT project that is extremely important to the welfare of the communication systems of this particular OPA. And now we're going to look at CPI, which I went around and visited a lot of these properties. It's not a light problem. I consider it a very serious problem. What I am wondering is, since this ad hoc committee has put specific timelines on certain deadlines to get this job done, and I'm not going to charge anybody to do anything, but I'm curious as to how this is going to be allocated out so that Bob can focus on these other important things. Not that this is not important, this is important. Focus on these other important things. How is that going to be accomplished? Is that a fair question?
I'm a bit puzzled because I'm not sure what the question is. How are we going to get the work accomplished?
How are you going to allocate any responsibilities with this?
My job
is that direct enough? Is that direct enough for you?
Well, I have staff that.
Okay, so who are you going to allocate it to staff?
Every job that we have gets allocated across all of the staffing.
Perfect. Good.
What's the question?
The question is, are you going to allocate it to staff?
That actually, okay, you answer yes. That's a dumb question.
No, well, I beg your pardon. What did you just say? What did you just say to me? You have no right to talk to me like that. Who do you think you are? Because, did you hear what I just said? Did you hear what I just said? Did you understand what I just said? All of the responsibilities that you have coming down the line that are important to this community. Now, I've worked with you for a year, but I have never, ever been insulted by anybody like that before in my lifetime. Okay. Now, this is a volunteer position, my friend. And I don't have to put up with this.
I owe you an apology. Hang on. I will apologize if I offended you. It was not my intent. Here's the question. Why would you try to put me on a spot and ask a question about something? Jack, would you let me finish before you jump? Please. You're trying to put a spot for, I don't know what the spotlight is. Of course, we allocate. We have Jerry Abate. You know this, and that's why I'm surprised you even asked the question after me. It's like you're trying to push into a corner unnecessarily. We have Jerry, who's our engineer, who's been working on the project. We have Sonia that's been working on the project. We have a great committee group that we've been working with on the project. I don't even understand the point. And I wasn't trying to be disrespectful. I apologize. I did come across a little short, so I apologize to you for that.
Can I make my point? I'm trying to be assistive to you, Bob. You do the best you can with the hours that you have available during the week. I know you put in a lot of hours around here, and you work pretty hard at it. I don't take that away from you. I just outlined to you some things that are very, very important to a lot of people within this community. All I'm saying to you is that, hey, if you're going to allocate this out to whoever you're going to allocate it out to, can you keep it on this timeline? They've got a timeline of September the 20th for a report back. All I'm doing is trying to indicate to you, is this a doable situation as far as this timeline is concerned? Did you see it?
No, sir.
Okay, all right. Let me show you.
are you referring construction by October 15th?
Yeah.
Okay. Realistically, I would say no for this reason. We can accelerate to meet the timeline, but all the board is given permission is to consider the project. There's no action item there. Now, from here, and what I was going to ask permission, because there is money to be spent, the next step for us, if the board endorses the project holistically, not paid for, it's not, we don't know that. We have to get those pricing. But to get anywhere close to this timeline, we're going to need to do a formal site plan. Tim did a great job drawing one up, but our next step would be to take in someone like Steve Soule and have him actually draw up a plan based on what we have. I don't know Steve's time frame, but he's usually pretty quick responding. So that would be next. So I cannot commit, no matter who it is, with me or anybody else, to a timeline, because then the next step we have is then we're going to have to take it to the county for. So we have third party being Steve Soule or someone else if Steve can't get to it quick enough. Then we have to take it to the county for. With that, we can start bidding on the project. But in between there, I have to take steps to the board for approval for the project. Yes, sir.
Do you have any swag on what's that cost?
For Soule?
Soule's going to have to do a site plan and a stormwater management.
Probably, if I had to guess, I'd tell you $2,000. It could go $500 one way or the other. But that's probably, you're in the building, right? I mean,
You can spend that on
close.
Yep.
It's not,
Okay. All right.
Just a swag.
you don't need a motion to move
No.
on that.
No, but I
No,
was
you
going to
don't.
make the board aware. That will be my next step. If the board induces, it says, yes, we support this, we'll get an actual formal site plan drawn up.
The consensus is clear, we support it.
Okay, you get my point? You get my point? I'm just,
Please don't ask that. I don't actually get your point, but I apologize that I snapped. It's that simple.
All right, moving on. Thank you very much. The next motion is CPI violation issues. I have drafted a motion. Here's how I want to handle this. I'm going to put this motion in front of the board. Hopefully someone will second it. I believe they will. We will then go through this motion, and I know many of you have gone out to look at these sites again. We will then go take each location and talk about it. And I will be more than happy to adjust this motion as we go through and change it if need be. But I will read the motion as it stands at this point. One of the issues that we were faced with at the last meeting was a bit of a implied conflict within MO1 between Section 9 and Section 10. Reality is, my reading of it, and therefore my first part of this motion, is that the Board of Directors hereby identifies all existing CPI issues that have been referred to legal for action to have been done under Section 9D of Resolution MO1, therefore authorizing legal counsel to continue to take action on issues until the issues are resolved, including filing suit to obtain actionable injunctions. What Section 1 here basically says is we're using MO1 as is. We don't need to change it at this point in order to keep moving on these issues. Number 2, calls for MO1 to be reviewed with an emphasis on Sections 9 and 10, just to see if there really is any conflict here. But those changes don't need to be made now. Authorizes the general manager to work in concert with the legal counsel to address and monitor all CPI violations which have been approved for action by either by the general manager or legal counsel. Requires any delay or barrier in progress which requires board action must be reported to the GM within 2 working days. Require a monthly status update report to be provided to the board at the monthly board meeting of all CPI violations which have been approved for action by either the general manager or legal counsel. Authorizes legal counsel to continue action, including filing suit on the following CPI pending actions until there is a resolution. And this is where we get into the various, and this was actually in the form of a chart that we had at the last meeting. But the first location location on this list was 14 Cape Town Road, which according to this chart from the last meeting, said that this had to do with a box trailer, and affidavits had been sent, and all I'm calling for is us to continue allowing the legal group to continue their work, and I'll take any changes or adjustments you want. Cape Town, if you have any.
This one may be exception.
That's fine.
There is an injunction on the
Correct. We have a question to Joe Moore. Joe, does that injunction allow us to remove the trailer, or does it simply call for the gentleman to move the trailer?
It calls for the gentleman to remove the trailer. So we need to do the same thing we did in Section 3, Lot 84, and that is request the court to hold that person in contempt of court, to either remove the trailer within 10 days of the order of court, or to allow us to go onto the property, remove the trailer, and assess all the expenses to the property owner. And as I say, we did this in the other matter, which was a commercial truck, which kept reappearing in the subdivision. What happened was that person, in order to avoid an actual contempt citation, entered into a consent order which said exactly that. Bob, as I recall, gave that consent order to Chief Massey and told him that if that truck was found in the subdivision again, that he was to have it towed and stored at the expense of the property owner. So we can do precisely the same thing on 14 Cape Town Road.
Yeah. And by us authorizing you to do the work under MO19D, you can continue to do your work, and that's all we need to do for that.
Yeah.
61 Moonraker Road.
Wait a minute, I have a
Yes.
question.
Yes.
In the violation pictures here, it shows the trailer over, like in the bamboo and all that. On Sunday, that trailer was moved to the middle of the house. Are they still in violation? Just having that trailer on there, we can go anywhere it is, just because they're moving it doesn't.
It does
we
not.
Grab it where it is.
That's correct. It's not an inoperable issue. It is the location of the box trailer within the subdivision.
Any other questions on 14 Cape Town? All right, 61 Moonraker, again, is another box trailer. Any more questions on this one? Or again, you would be working this one under 9D, under M1, that allows you to do legally whatever you need to do to get that taken care of.
First, you need to catch it there. I've been there 3 times. I haven't seen it.
Okay. 37 Battersea Road.
Did you skip one? What happened to Cape Town?
Well, Cape Town's further down in my motion. That's a clean.
Those are the other actions.
Okay, sorry.
Those are the highlighted in red actions.
Too many lists.
Okay, 37 Battersea Road. Again, is a bulkhead attachment, same issue. Unless there's any objections, we will let Joe keep moving under 9D. 52.
I could not see that. I couldn't get it.
From the road, right. I couldn't even. 52 Battersea Road, one of our favorite comments, junk vehicle. One of my favorites. Again, the issue is not just whether it's got a flat tire or not, it's whether it's operable.
Mr. President,
yes.
Perhaps this is a good time for me to make a comment to the board on how I feel about junk vehicles. It's been
That would be fine, Joe.
I have said, and I will say it here publicly, that with respect to anything that is considered in a reasonable manner by CPI staff and or the board and or the general manager to be a junk vehicle, I will proceed to file a complaint for injunction to remove that vehicle. I have said it doesn't bother me whether in 1, 2, 3, or 4 cases, Chris Woodley or I in court crash and burn if the person comes into court and proves it's not a junk vehicle. But to err on the side of caution has not worked, it seems, very evident to me. So we need to determine I've said it before, and the only way I know to do it is you may not be able to precisely define it, but you know it when you see it. Well, if we get guidance from the court as to what he will and will not consider a junk vehicle, I suggest to you it's probably going to be on a case-by-case basis. But it doesn't bother me if we are possibly going to lose a case. God knows in 45 years I've had enough of that experience to get used to it. So it is something that needs to be taken care of. I'm perfectly willing to do it and to see what the reaction of the judge is. And I don't want to go on too long, but we got a reaction from the Judge Bloxham, when we filed suit on maintenance issues where he said we did not precisely follow what he considered was the clear language of the restricted covenant. So that gave us guidance on when we could or could not file those kinds of suits. I suggest the same thing ought to be true of junk vehicles.
Should we lump them together? I mean, we can read them off right now.
Oh, I'm fine with it if everyone's comfortable with that.
We got 52 Battersea Road.
Yeah, 52.
Anybody has a question about what junk vehicles look like, stop, look. Number 8 Willow Way. That one may be out 52 for junk. 12 Brookton Lane. Junk. 32 Battersea Road.
Okay, hold on. You can't go there on that. I got to stick to my motion here, Marty.
Yes, he's reading his motion.
I got to stick to my motion so that we. I know.
Cut some corners.
Bottom line is under number 6 on this motion, you have a list of issues that have already been referred to legal for action. This motion simply allows legal to work under 9D of MO1 and do whatever they need to do legally to take care of it and to keep moving.
There's problems with some of those under 6.
Okay.
For instance, 74 Preston.
That was one I knew that was going to come up.
That's a matter.
Don't we need to read the motion, get it seconded, then discuss?
Sure, let's go ahead and do that.
Let's do it right. Okay.
Thank you.
You read the motion, right?
He's in the process
I'm in the
of
process
it. Keep
of
interrupting
reading
him.
Just
Dear God.
I'm working the issue here. Okay? Trying to get some. 70 Crest Haven Drive is another one. 74 Crest Haven Drive. 54 Nottingham Lane.
58.
58. Thank you. 58 Nottingham Lane. All of you did. Okay. 8 Willow Way. And under Section 7 of it is authorizes the general manager to take appropriate action to resolve issues, including having OPA staff perform maintenance and bill the property owner for any costs incurred by the OPA for 52 Battersea Road, 73 Windjammer Road, 255 Windjammer Road.
Excuse me,
52 Cape Town Road. Can you read your own?
No, I can't.
Would you like me to finish this?
No, that's fine.
I mean, do you want us to read it for you? Or?
You're already on a roll.
I'm sorry.
52 Cape Town Road, 73 Windjammer, and 255. 8. Authorizes the general manager to work in alignment with the ARC to address the addresses below. A ARC session on 8/15 for 8 Juneway, 11 Juneway to be re-inspected. For Section 8 of MO1, the address below are designated as fast-track CPI issues and authorizes the general manager to take appropriate action to resolve cleanup issues, including have an OPA staff perform maintenance and bill the property owner for any costs incurred by the OPA. In addition, the board pre-authorizes fast-track action to be taken, including cleanup or referring to issues to legal counsel for action, including court action, for both 8 Juneway and 11 Juneway. 9. Board finds the property below to be in continuous violation of having junk/inoperable vehicles on the property and authorizes the escalation immediately to legal counsel for any legal actions needed under Section 9D of MO1 or the general manager actions needed to resolve the issue at 32 Battersea Road. 10. Authorizes legal counsel to proceed with filing suit in a matter of Seven Gate House, which is a burned out house which has been burned out for 2.5 years. The background of this motion is there is a backlog of CPI violations which are pending for approval for future action. There is also a section of MO1 which needs to be reviewed for its unintended impact for greatly slowing down legal action taking for OPA which are related to CPI violations. Therefore, an action is needed to clarify which section of MO1 will apply to CPI actions that is being referred to legal action. What that means is when we refer something, we need to refer it as being under 9D. The effect of this motion is to allow the backlog of legal work to move forward quickly. Clarifies that all current CPI referrals for legal action are under Section 9D of MO1. Fast-track CPI issues which are currently in discussion among the board. Enables legal counsel to file suit on a burned-out house and moves MO1 for review. That is the motion. Is there a second? All right, now discussion. Back to the motion. Any adjustments, changes? I know a lot of you looked at the houses so live, so changes with Marty.
First, I know 99.9% of these have been found in continued violation, but I think they should add it to 6, 7, 8. And I think it's already in 9.
If they've already been, that's already happened.
It may or may not have. I wasn't here for that.
I'll add it. Yeah. All right.
Doesn't hurt to
going.
find them in
Keep
continuing
going.
violation twice.
Okay.
Secondly, in your number 6 here, number 74 Crest Haven.
Yeah, I knew we were going to talk about it.
Number 7 Crest Haven.
Yeah.
70 Crest Haven is a dilapidated camper shell that's sitting beside the house. So that one really, that needs to go. 74 Crest Haven, we voted to go on the property and clean it up, remove metal fence. And we have not done. That's.
Okay, well, I get an explanation then, because that's one is marked, Joe, as being legal action, as opposed to what Marty's talking about on 74 Crest Haven.
74 Crest Haven had two parts to it.
Okay.
We wrote a letter on the junk in the yard, and then the issue of the fence came up. Now I've got pictures of the fence, and it's a bad looking fence. It's a I guess a half brick chain link.
It's a metal chain link dog.
Yeah. The normal process when you literally take something that is not trash, and I recognize because it looks awful bad, but the normal process on things like removal of fences, and we've got another one. I think walls are either going to. Yeah, it's a brand new one, but that normally is not to go on and remove something that has at least, colorable value. You know, it's not something that you throw to the dump. And Marty,
I'm pretty sure you could walk away with the house and not make anybody mad. There hasn't been anybody in it in 5 years.
Okay. Well, then, and as I say, that fence is. I've only seen a picture of it. I haven't been out there, but. If the board wants to accede to that, then I'm not going to stand on the other fence that's coming up. It's a whole different story.
That's the one in the waterfront lodge.
Yes, that's it. But on this one, it's borderline enough. I didn't realize it probably this bad, and I don't know that, from my input. So, if the board wants to take action on paragraph 14 of the Declaration of Restrictions, that's
in the minutes from September of 12, 74 Crest Haven. Property was okay. First floor to DO 2011, CPI has asked the board to approve Public Works Department clean the yard, remove the fence, and fill the small pond. O'Hara moved to accept. Under seconded, the motion was by all board members except me, who abstained.
So you liked the fence back then?
I didn't like it. I hadn't seen it. This was one of those issues where we got it.
For the purposes of this motion, are you suggesting that
that gets moved to the next
74 Crest Crest Haven Drive gets moved down to 7.
7. That's my suggestion.
Any objections to that? Any other questions or adjustments besides the continuous on violation?
Well, yeah. One more.
All right.
God. Windjammer. 73 Windjammer.
Yes.
It's been fixed. I mean, somebody's made a valiant effort. They cleaned it up. They're working on it. It's a new owner for ECC. I think you can take it off the list, personally.
I would prefer to actually leave it on the list and let CPI verify that. I trust you've
They
seen
did
it.
verify it.
Okay.
I mean, I was in there the
Then
other
let's
day.
take. Okay. I'll remove any
So
objection to
there's
that.
a new owner,
That's what Dino thought. He's pretty sure there's a new owner.
so they bought it subject to these restrictions, violations?
You know what? How would they know there's a violation? If
Because they should have gotten a resale
If they
certificate
bought it
saying
in
that.
foreclosure, nobody gave it the same back.
We know they bought a foreclosure.
I don't know anything about it. I just know it's
Okay.
cleaned up.
There's no point in us including that. Any other comment?
I would not agree to take it out unless we know.
Then leave it in. Let's just make another stop.
We'll leave it in. You can verify. All right, there is one. Yes, Bill.
255 Windjammer. There, all weekend there was 2 trucks there and a full trailer that they had windows and all that kind of stuff in. The problem is they're working on it, but they've made it worse by working on it because they've taken windows out, put in plywood and all that kind of stuff. It looks worse than it did with the original violation. But somebody is working on it, but it just needs to. We need to stay on top of it. Like I say, that it's right now it looks horrible. It looks worse than the original violation. But they're working on it. They were there all weekend.
Again, I think this motion authorizes the general manager to take appropriate action.
Yep.
So that takes care of that. But I appreciate that information. All right, there's one thing here that I want to make sure we're very clear on, and that is number 9, having to do with 32 Battersea. I left a voicemail for and been in email communication with the head of DART. Not heard back. I just want to make sure we're all clear here. 32 Battersea Road has not been through the ARP.
Neither has 7 Gatehouse.
Okay, I'm just making sure that we're aware of it. That's all I'm.
Again,
I just want
pull
to
the trigger.
Okay.
We're going to make a mistake.
I want to err on action, but at the same time, I want to make sure everybody's clear that 6 and 7 and 8 were all ones that had gone through ARC. 9 did not. 10 was a burned out. Joe, number 10, 7 Gatehouse.
Yes, sir.
Kind of explain where that one is, and the next thing on there is your lawsuit that you propose that we do.
Yes. The thing with 7 Gatehouse Trail that has hamstrung us is that it has been in foreclosure, and there are, if anybody reads any of the legal ads, there are law groups that do foreclosures by the dozen, if not by the hundreds in Worcester County. And this was one of them. So we were in foreclosure. The house had burned. Obviously, the people gone. And we had no owner that we could notify to say the violation. Now, this violation is different than most of them, and I'll read it to you in a minute. But we had no owner that we could notify to say, you're in violation and here's what you have to do, or we are going to ask the court to allow us to do it. That resolved itself when the lender bought the property in at foreclosure and actually took title to it. Now, everybody knows that a member of the association is not a person who holds a lien or a mortgage on a property. It's the property owner themselves. Well, our good fortune is that U.S. Bank National Association, I haven't heard of that.
Yeah.
They're a big outfit.
Yeah, fair.
On behalf of Mortgage Equity Conversion Asset Trust, became the property owner. So on June 9th, Chris Woodley, in my office, wrote a letter to the new owner advising them of the provisions of the Declaration of Restrictions, which is different because it is Section 8 of the Declaration of Restrictions, which provides that any dwelling or outbuilding on any lot in the section or the subdivision which may be destroyed in whole or in part by fire must be rebuilt or all debris removed and the lot restored to a sightly condition with reasonable promptness provided, however, that in no event well, Tom, you and I are at it.
Here we go.
Shall such debris remain longer than 60 days. And Woodley says, as the new owner of the above referenced property, your company is now responsible for that condition. And we sent that to 5 different parties, including 2 lawyers. The lawyers who are the resident agents in Maryland for this organization, which is in Louisville, Texas, and Howard Bierman, who is a foreclosing attorney. So, that we had not heard anything. So, yes, sir.
One comment. It's actually not a violation until a vote is motions.
Well, I disagree. I know we can debate that nicety, but when you have a fire, the restriction in my judgment is that is a self-effecting restrictive covenant. It has to be restored within 60 days, whether this board determines that the only thing you can do is determine whether or not a fire occurred. And I think everybody has a photograph of this building. Respectfully, Marty,
we just saw this last 3 days.
Right, I understand.
So we talked about 2 years. 3 days ago, I heard about this.
Right. So this is, and again, I've been debating everything. Is Jim here? Jim Trump? Jim and I have been debating, so I might as well debate with you. I see a difference in a house that is destroyed by fire like that. And respectfully, I don't think this board has to determine that that action has occurred. If it's destroyed by fire, it's supposed to be repaired or raised. And that condition in the restrictive covenants say that it has to be done within 60 days. So that's a self-effecting fact. But
until we find it in violation and go after the people, nothing is happening.
Well, I disagree. I think that's a nicety that you don't have to go through that. But let me ask this then. I am presuming you're about to make that motion to find me.
Indeed.
Okay. So we've got an injunction ready to go, and the only thing I'll add, Mr. President, because when I went back on the other one, I think that I will add the additional request of the court now in that injunction to order them to show cause. Number one, they have a right to show cause why they ought not to have to raise the bill. But if they don't show cause and do not remove the building, then I'm going to add an additional request to the court to allow us self-help now rather than going back after they don't do it if the judge enjoys it. You can always strike through that second line of my injunction order. But this thing, I'm like you, Marty. When I saw this picture, I thought, my God, that thing has been there for I forget how many years. But it's an abomination. Man, that's terrible.
You know, from the street, you can't tell the fire there.
Right.
You need to get out and walk down a drainage.
You do.
Well,
actually, we found out this actually came from a call I got at my house about 2 months ago, telling me about this house. That's how we found out about this. Yes, sure.
That's part of my point I want to make. We don't know. We don't have people going around, driving around looking for problems. If someone has a home in their neighborhood that is in disrepair or is been burned down or whatever the situation, you need to report it.
That's right.
I did that on my street. It needs to be called into CPI, and then they'll get on the list, and then they'll start acting on it. But if we don't know, we can't do anything about it. And I think that's the important point that needs to come out. This house has been burned down for 2 years, and we don't know about it? How does that happen? I don't know.
Marty's right. You could drive right by that place and not even.
You can smell it.
You driving by, you can't see it through the trees. Okay, so I'm only going to update that portion of the motion which needs to be up. Number 6 is now authorizes legal counsel to continue action, including filing suit until there is resolution, and finds the following CPI pending actions to be in continuous violation. Number 7, same change, authorizes general manager to make appropriate action to resolve issues, including having OPA staff perform maintenance and bill property owner for any cost incurred by OPA for these locations which are found in continuous violation. Yeah, we're writing down the motion as we're going through it. So what?
Do you like copy Robert's rules?
Yeah. I sleep with it every night.
You don't mind
Okay.
Tom, you don't mind a little levity here. If you follow Robert's rules, you have to read the motion again after.
I know what Robert's rules says. So, the motion has been read, seconded, we've had our discussion.
Do we need to do anything on number 10 for Joe's request with the 7 gatehouse, or is that worded okay, Joe?
7 gatehouse is fine.
Is worded okay?
Any other questions, comments? All those in favor?
Aye.
Opposed? Thank you very much.
Good job, Tom. This took a lot of putting things together. Thank you.
You're welcome. Thank you. Okay. Moving on to the review of general manager's objectives for this current 14-15 year. We had a list sent out to everybody in advance actually about a month and a half ago for us to discuss. We had a report done. I think, Jeff, you pulled this together for everybody of all the people's inputs to it, and we ended up with the following list and statement, which I will read for everyone so that the audience can know what we're talking about. Beyond the financial and budgetary objectives already set in the contract, we would propose the following high-level objectives be set for this year. These would be the core of the assessment to determine the amount of bonus that is tied to non-financial results. Possible listing of objectives. Number 1, deliver to the board an IT plan for updating the OPA's network, measured by its completeness and accuracy. And I'm going to add to what you got in the mail a suggestion that this be done by January 2015. 2, we'll come back and talk about it. 2, coordinate with the county to represent OPA interests in the water line replacement program and develop and implement an OPA plan for oversight. Again, measured by the quality implementation of the plan. This is a fall project. Depends on when the county actually starts digging lines this year, 2014. 3, update CIP for presentation to the board, measured by its completeness for a plan proposed action through 2020. Date I put on that for discussion is December 2014. Yacht club operations, measured by quality of service, speed of service, quality of food, completion of building. Those would be monthly reports coming in the general manager's report. 5, drainage team operations and drainage strategic plan, measured by its responsiveness and quality of operational work, plus the quality of a long-term plan for action to address OPA needs. This would run to March of 2015 for the bigger plan, but obviously the drainage team will be working daily between now and then. So those are the dates that I've added to what we're in front of you. January 2015, fall project, December 2014, be part of the monthly general manager's report, and then March 2015. This is an open discussion on this. Whoever wants to add something.
Well,
say something.
wait. There were some additional items that were added, and believe it or not, Sharon and I agreed on several. Revise the guidelines and restrictions for junk vehicles and overgrown landscape and abandoned houses. That was added by Jack and Sharon. And communication with all board and association members, returning phone calls, responding to emails, responding to issues brought to GM by the board, the OPA members 3 days prior written notice of items to be discussed at regular board meetings. That was added by, let's see, it was by Jack. That's it. That was just mine.
End of Jeff's summary. 5 things listed there. Things that didn't get onto this list, which I think is the revised junk car derelict process, which we just got talked about. And the communications to the general board of directors is already part of the evaluation process, evaluating his function anyway.
Okay, go over that again. I got it. I got that. What was that point before that?
The only one that didn't get transitioned from this report over to here was the junk car. Rewriting that. Well, we can add it. I'm not arguing. I'm just saying that's the only thing that was in here that isn't already in the process. And so if you want to add the rewriting the junk car.
Well, it's the pleasure of the board. I mean, you know, Sharon and I are thinking like on it, but it's the pleasure.
If you want to add that, I'm not going to argue one way or another. So, you want to add that? Yeah. Number 6, revise the guidelines and restrictions for the junk vehicles and overgrown landscape and abandoned homes. Yeah. Just revisit that.
You might even use the word derelict in there or something. Maybe.
Feel free to respond.
Well,
we may still say it, but go ahead.
Well, no, I mean, you put it in there, but I thought Joe just shared with the board, and the board agreed what was going to be considered a junk car was going to be determined by the court. We have 4 of them that we're going to take and let the court tell us if it's junk or not. Is there something different here that the board's requiring?
I mean, just have a right to know what it is the deliverable is here. That's
Well,
it.
just one phrase that Joe described junk vehicle, not only what junk vehicle are built.
So what's my
The
deliverable?
board might disagree.
Yeah.
I don't know.
Well, the question is, what's the deliverable?
I think we need to focus on the word derelict, and maybe that isn't even general enough. But it's basically the spirit. I mean, if you drive around Ocean Pines and you look at some of these homes, you scratch your head and you're saying to yourself, why aren't these people neighborly, to their other neighbors? Their houses are not in very good shape, and it has an impact on their individual property values. And as Sharon has indicated aptly, that you call CPI and CPI investigates it. So that's the spirit that we're addressing, not just junk vehicles, but things that are not in compliance with the overall living standard of Ocean Pines.
I have no problem with anything you just said, except I need to understand what is the deliverable for the general manager.
The only way to do that is to say, is an inventory. You have 97 derelict houses today, 14 junk cars. And if we get it down to 12 and 11, there's a benchmark. Other than that, I don't know how you do it.
When when I wrote those thoughts, we had not gotten as far as we have today. And by what we've done today, I'm feeling a lot more comfortable. And I think that Joe's got a good handle on how to handle this. And it sounds to me, if there's a building that's in disrepair or if there's a junk vehicle, that this board can go go ahead and say something, and he will deal with it from there and take it. Am I correct on that, Joe?
Yeah.
I don't know if we have to change our guidelines to do that. We might want to say it needs a valid license tag. I don't know, but
No, actually, that was removed.
that's removed. Yeah, that's removed. So I'm not so
February
sure we need
2010.
to. I think I had this concern more before what's happened today.
So if you leave it, we've already met that requirement.
So you already.
So now you want it on there. All right. Yes, sir.
Couple of comments. I would certainly defer to legal counsel on this, but I would not pick another word to complicate. It's like derelict. I doubt that that's well defined. I would stick with a junk car or abandoned car. Talk about cars. I think the substance of this is to take the learnings that we get from wherever we get them. If we get them from judges in court, that's great. They teach us what they will accept. We should then take their knowledge and our work and write that down somewhere. That's what I was thinking about when I was looking at this. So the deliverable is to take this learning, kind of condense it in a readable form, and then write it down so we have it. Maybe that's the new MO. I don't know. But that's what I was thinking when I looked. So there is a deliverable. And there is learning that comes from what the judges tell us. It'll at least tell us what they will accept or what they think comes to accept. And then we write it down, all of that stuff, and begin to use it.
But if we're talking about a new MO1, which I think a lot of people, including Marty Emmett, said that's not involved. Is it? No. You were talking about the section in MO1.
I said it. Yeah, you're right. That's a board thing. But I still think there are internal procedures that we should write down. And if it's nothing more than an edit and reaffirmation of what we have, great. I would like to see a new one of those that says, this is what we're going to do today, this 2015, 14, whatever. There it is. And it comes from sources. And the things that are the boards, like MO1, then to get our butts. Yeah.
Well, maybe this is not a good analogy, but I brought my letter to Mr. Thompson in July of 2012 when I advised that Judge Rick Bloxham has stated to Chris that our ARC enforcement cases on property maintenance do not in some instances comport with the interpretation of the maintenance requirements set forth in paragraph 4A of the restriction which states all lots, whether occupied or unoccupied, go on. What Judge Bloxham said was it has to be alleged that it is by reason of unattractive growth on such lot or the accumulation of rubbish or debris thereon. And what I thought about, Jack, was if we get there trying to impose a definition on the judge that is not in the restrictive covenants, we may run into the same thing. So I'm satisfied to have a quote-unquote junk vehicle determined by the board to be junk, and then let me go and see whether or not the judge agrees. And as I said, that may very well be, it may very well be on a case-by-case basis. But at least it gets this board not having to try and explain to the folks who say, I've got a junk vehicle next door and it's been there for 2 years and I want you all to do something.
Joe, if I may ask a question. Things that come across your desk that we have said, okay, go ahead and go to court or go to talk to the judge about this. What time frame should we expect a response? Because the neighbors want to know, when are they going to hear?
Well, I just I had to reschedule a case today that has been scheduled for October, and we rescheduled it to January. So there normally is a time lapse because we only have 10 civil trial formally or informally assigned by Judge Groden to deal with Ocean Pines restricted covenant cases. So we can set 10 restrictive covenant cases in one day, and Mary Serpy, the assigned clerk, frequently does that, because in many instances, as you know, they never get there, because when somebody receives a lawsuit, it's all. It is not an instantaneous thing, because what the judge does is, when we file suit, he then signs a show cause order, and that person then shows cause by filing a written response. And then the case is set in for a merit trial. So in these injunctive relief cases, there are two things.
So logistically, and help me out, because I honestly don't know, but if you go to the court, file a court case, okay, then the judge asks the other party to respond to it. And at that point, because now they know there's a lawsuit out there where it's serious, going to court, they may just say, I'm moving that junk vehicle out of there and not go to the court expense. So it could theoretically be done. Am I correct?
Yeah.
In the event they're going to play hardball and they say, okay, we're going to fight this. This is not a junk vehicle. This is my favorite car that I had my high school prom. They want to have this. So then they would go to. So it could take 3 or 4 or 5 months.
Yes, but I can provide you all with court assignment dates so that you know when those cases are being assigned. Yeah, Marty.
Would 14 Cape Town and Dirty Deeds truck be a good indication? Because there's 2 that we busted our shops get, I think.
Yeah.
So 14 Cape Town took 2 years. The date violation was filed May of 2000 to June of 2012, that injunction. And the violation is there right now.
Still there.
So, I wouldn't tell anybody in 3 months.
Let's not debate that particular piece of.
Well, if you're picking up, the Dirty Deeds truck was 2 years.
The point is that with Sharon's question is, I think, the comment you try to make sure is in some cases, us going to court will turn it around quickly. Other cases, it'll take court time. Good luck. Take quite a while. What we're looking at now is deliverables by the general manager, and what I have now written down as part of the suggestion from both our legal counsel and Bob at the last board meeting was for us to revise part of MO1, which we haven't done tonight, but got through that issue, till December. So I have written the following deliverable. See if this fits. It's deliver a summary of suggested changes for internal procedures for our guidelines and restrictions for junk vehicles and overgrown landscape and abandoned homes by December 2014. Put into a document our lessons learned from this escalated effort and provide that back to us so we have, after from now until December, what have we learned in that period of time? And in that time, let's not run off and redo MO1 at this point. Let's find out what we need to do and not do.
One of the things I believe it's all in policy. General manager is supposed to have MO1 for review every 2 years. Is that right?
You just went through the whole cycle.
Yeah, and we also have other policies.
It's a cycle.
Wouldn't you just make that policies responsible of the general manager?
Well, again, I'm just trying to get a deliverable having to do with this particular thing that both Sharon and Jack added to this
But I think you're
list.
picking on one.
What about reporting on a regular basis the status of any one of these cases?
That was in my motion. We just passed. That's it. To do that.
Right. And that is part of this same deliverable, correct? So the only issue at today, as far as potentially number 6 that Sharon and I are talking about,
right?
The only potential use that it has, if we're all going to follow and that are in disrepute, however you define it.
Right.
Then I agree with Marty. I don't know how you how you would quantify it.
I'm just
how unless like he said, if you want to keep score, like I think Bob did this. This thing, right? Okay. You want to keep score like this and see how far we work it down. You know, with a combination effort of legal and staff and Bob. You know, that's a measure. Does that make sense?
Again,
does that do you any good? I mean, if it serves no value,
I'm not so sure what it's needed.
if it serves no value,
this point. Again, I think Jeff, you were the one that kind of helped us lead towards some kind of deliverable here. Are we decided we don't need to add number 6, or where are we?
Well, I think 6 is a good add.
It's worth doing.
I think it's worth doing. Just kind of like this. It's worth it.
Thank you. I mean, again, let me read it again. Deliver a summary of suggested changes for internal procedures for our guidelines and restrictions for junk vehicles, overgrown landscaping, and abandoned homes by December 2014.
right, and that was the process
Okay,
that
then we'll make that number 6.
Right.
Any other changes or adjustments to this? Can I have a motion to accept these as the objectives?
Motion to accept.
Have a second? Any more discussion? All those in favor?
Aye.
Vote.
Jack, did you vote? Jack?
What?
Did you vote?
For what? Well, I'm in, for whatever. I'm in favor.
Okay, I will, Jeff, motion to go into closed session.
I move that the Board of Directors adjourn to closed session for the purpose of discussing personnel issue, specifically the general manager's evaluation, as permitted by the Maryland Homeowners Association Act, Section 11B-111 sub 4 sub I.
Have a second?
Whatever.